Welcome to the Explainer. Today, we're unraveling a massive, completely unprecedented constitutional puzzle that the South African government was forced to solve back in the mid-1990s. Imagine this scenario. The highest court in the land absolutely abolishes the ultimate punishment, the death penalty, but they leave hundreds of people who were already sentenced to die in a complete, absolute legal limbo. So how exactly does a newly democratic nation clean up the most severe remnants of its past justice system without breaking its brand new constitution? Well, that is exactly what we're looking at today through the lens of a landmark constitutional court decision, case CCT 45/04. Okay, let's dive into this. 300 to 400. That's the estimated number of human beings stuck in a bizarre, almost unimaginable legal holding pattern on South Africa's death row back in 1995. You see, the death penalty had just been declared unconstitutional, but that ruling didn't just magically wipe away the sentences of those who had already been condemned. It really just meant the state could no longer execute them. So you have to ask yourself, what do you do with 300 to 400 people whose sentences are suddenly impossible to carry out? So here is our roadmap for unpacking this crisis. We'll start with the death row dilemma itself, move into the legislative fix, the constitutional challenge, the battle between fair trials and fairness, the separation of powers, and finally, the final verdict. Let's get right to it. Part 1. The death row dilemma. A punishment abolished, but sentences remain. To really ground this in reality, let's look at 4 men. Willie Aaron Sibiya, Purpose Khumalo, Jacobus Petrus Geldenhuys, and David Nkuna. They were caught right in the middle of this historical timeline. The last execution in South Africa actually took place in 1989. By 1990, the government placed a strict moratorium on executions, even though courts could technically still impose the sentence. Then came 1995. The landmark Makwanyane decision officially declared the death penalty inconsistent with the interim constitution. But, and this is an absolutely crucial point, the court made that ruling prospective, not retrospective, meaning it didn't invalidate the sentences handed down before June 1995. It simply forbade the state from carrying them out. And that created what we can really only describe as legal purgatory. You have literally hundreds of inmates who are lawfully sentenced to die under the old rules, sitting in maximum security prisons, constitutionally protected from actually being executed, but with absolutely no idea what their actual punishment would be. They were just waiting, literally for years, for someone to give them a new sentence. Which brings us to part 2, the legislative fix. How do you re-sentence hundreds of people? The government obviously couldn't run hundreds of brand new, full-blown trials, right? It would take years and completely drain the justice system's resources. So Parliament stepped in and created a rather unique solution, the Criminal Law Amendment Act 105 of 1997. Let's map out exactly how this streamlined mechanism worked. Step 1. The Minister of Justice refers a death row case back to the court where the sentence was originally imposed. Step 2. A judge, ideally the original trial judge, reviews written arguments from the prosecution and the defense, alongside the original trial evidence. Step 3. Based purely on that paper review, the judge advises the president on an appropriate alternative sentence. And finally, Step 4. The president formally sets aside the death sentence and substitutes it with the punishment advised by the judge. Now, it was incredibly efficient, for sure, but it lacked a few critical things we normally associate with the justice system. There was no public trial. There was zero right to present new oral evidence. The inmate didn't even have to be present. And crucially, there was absolutely no right to appeal the president's substitution. This streamlined efficiency perfectly sets up our impending legal conflict. Part 3. The constitutional challenge. Inmates sue the system. You can imagine our 4 applicants felt completely robbed of their rights, right? So they sued, arguing this paper-shuffling mechanism denied them their basic trial rights, and they actually won a massive initial victory. The High Court declared the mechanism completely unconstitutional and invalid. Their reasoning? They stated, quote, "Proceedings do not take place in public. No evidence may be adduced, no right to access the reasons. Sentence is imposed by the president, not a court of law." The High Court essentially said that because this process didn't look like a traditional trial, it directly violated Section 35 of the Constitution, which guarantees fair trial rights. Moving into Part 4, Fair Trials versus Fairness, Section 35 versus Section 12. Because this involves striking down a law, the case went straight to the Constitutional Court, landing on the desk of Justice Yaqub. Now, what's really interesting here is how the court viewed the law completely differently. Let's contrast these 2 pieces of the Constitution. The High Court relied heavily on Section 35, the fair trial rights. But Justice Yaqub pointed out a critical, game-changing detail. Section 35 explicitly applies to accused persons. These inmates were not accused persons anymore. They had already been fully tried, convicted, and sentenced under the old laws. The judicial process was entirely over for them. Therefore, Section 35 didn't actually apply. However, Section 12, which protects all citizens against arbitrary or unfair deprivation of freedom, absolutely did apply. So the question for the Constitutional Court wasn't, is this a perfect trial? The question was simply, is this process fair? This state argued for what they called a change in the sentencing paradigm. The core argument was that this wasn't a new trial because, well, a new trial simply wasn't needed. These inmates had already gone through rigorous trials where the death penalty was deemed the absolute only proper punishment. The only reason it was being changed was an administrative necessity. The old ultimate punishment was gone, so they needed the new ultimate punishment, like life in prison. A protracted, drawn-out retrial wouldn't magically produce any new evidence anyway.
Part 5. Separation of powers. Who has the right to judge?
Now, even if you buy that the process was fundamentally fair, the applicants launched a second major attack. They questioned whether the branches of government were illegally overstepping their constitutional bounds. Was the executive branch doing the judiciary's job and vice versa? Let's break down these two complex criticisms. First, critics said judges shouldn't be doing administrative paperwork for the president. But the Constitutional Court replied that assessing court records and written arguments to determine an appropriate sentence is a deeply judicial task. It's exactly what judges are trained to do. Second, the critics argued that the president, a politician, was imposing a sentence, which is strictly a judge's job. But the reality, as the court pointed out, is quite a bit more nuanced.
We have to remember, the executive branch already has massive powers to alter sentences once the judicial process is totally complete. The president can grant pardons, remit fines, and place people on parole. In fact, even under the old laws, the president had the power to commute death sentences and replace them with another punishment without asking a judge at all. So the fact that the president was now substituting sentences, and doing so based on expert judicial advice, did not violate the separation of powers. It was completely valid.
And that brings us to Part 6, the final verdict, resolving the legal purgatory. So, with a mechanism that doesn't offer a full trial but doesn't violate the separation of powers either, the Constitutional Court made its final decision. They completely overturned the High Court. Justice Yacoub wrote that the mechanism was, quote, sufficiently fair to cater for the exceptional circumstances. It wasn't perfect by standard trial metrics, sure, but it didn't need to be. For a truly unique, once-in-a-lifetime crisis where hundreds of finalized sentences suddenly became unexecutable, a paper review substitution process was entirely constitutional and fair. But before we completely close the book on this explainer, we have to acknowledge a frankly tragic administrative reality. In 1995, there were about 350 of these cases. By 2004, when this legal challenge started, there were still 134 people waiting. And in 2005, when the Constitutional Court was handing down this very judgment, a full 10 years after the death penalty was abolished, there were still 62 human beings waiting in legal purgatory for an answer. The mechanism was constitutional, yes, but its execution was painfully slow. And let me tell you, the Constitutional Court was not happy about this. They didn't just rule on the law and walk away. They forcefully intervened. The court issued a strict supervisory order. They demanded that the government replace all remaining sentences by the end of June 2005. Furthermore, they ordered the government to report back to the court by August 15 with names, dates, and explanations for every single case, retaining supervisory jurisdiction to make absolute sure the government actually finished the job. And that profound tension right at the heart of this case leaves us with a provocative thought to reflect on. Is a perfectly fair constitutional legal mechanism truly just if administrative delays leave human beings waiting a whole decade for an answer? Designing constitutional theory is one thing, but executing real-world justice is another entirely. Thanks so much for joining me for this explainer, and I'll see you next time as we continue to unpack the fascinating ideas that shape our world.